Hi, everybody. Welcome to this webinar that we're doing this evening. My name is Maureen. I'm the founder and creator of BarMD. We are a full service bar prep company covering the UBE, California, other jurisdictions as well. So anything you need, we can help you with the bar exam, whether it's one-on-one, full courses, etc. The thing that we really pride ourselves on, the thing that I really try to do and do very well, is we show you how to pass the bar exam and how to do each of the components that you have to do for the bar exam. So how do you write a passing essay? What does that look like? How do you get there from like nothing on the page to a full good answer? What does it look like when an answer is just passing versus a high scoring answer? We show you how to get there. Same with the PT. We walk you through step by step. Same with the MBEs. I really show you how much and how deeply to deconstruct the questions when you're practicing so that when you get to the exam, you know how to deconstruct the questions effectively so you can finish in time and not just be stuck between two answers so much of the time, which happens for a lot of people. So that's what we do at BarMD. And tonight I'm going to walk you through and just talk through the issues that were presented on the July 2025 MEEs and on the MPTs. I'm going to drop right now and I'm going to turn the chat off. If you have a question that you want me to answer, please drop it in the Q&A so that I can get to that when I'm done walking through the questions. And if there's like a question about a particular fact pattern that you want, I will see those as well. But when stuff is popping up like crazy in the chat, it's a little bit tough for me. So I'm just going to turn that off for now. And I'm going to put in the chat, there's a link to all of the essays. There's a link to all of the essays, and I just dropped that in the chat. So if you click on that, I'm going to put it up on the screen as well. But if you click on that, you'll be able to follow along nicely and easily if you want to read along instead of just listening to me. And then I've got my presentation where I talk about what is covered in each of the essays and in the two PTs as well. Let's get this. Okay, let me redo that. Okay, so first, just a couple of things. We're gonna talk about the July 2025 exam. All right, but just a couple of free things that I want to mention. A totally free thing you can do is you can schedule a strategy session. If you got results from the bar and you weren't successful, or even if you're taking it for the first time, you can have a strategy session with a member of me or my team. It's totally free. We'll talk about, what do you have? What are you worried about? If you got your scores and you want to be able to interpret those, what does that look like, etc. So I'm going to put a link in the chat where you can schedule a time to meet with me or a member of my team for free. So that's that. I just dropped in the chat. We also have our podcast. There's a ton of good episodes on there, and I have started updating it with some new stuff as well. And we also have a ton of really great free stuff on our BarMD YouTube. We also do drop some of like these lectures, these free webinars that I do. We drop those into people that are members of our YouTube channel, get access earlier, and some other stuff that we put on the YouTube as well. So go and check those out. And the podcast is just called the BarMD podcast. So, and I'm going to be doing some stuff like walking through essays on there and just all sorts of fun stuff. So a lot of good stuff planned. I also just want to mention, and I'll talk about this, but our Core with MBE program is starting in about 2 weeks. So I just wanted to throw that out there. Well, we have a program that started on the 1st that you can join, but the live classes start in about 2 weeks. And this is we've revamped it for the upcoming bar exam for you guys so that there's a lot of live classes where I'm teaching all of them for the MBE, for the essays, and for the PT. And these are going to be such a good deep dive. It's going to hold you accountable, make you get the work done, to show up with your work done, to be able to ask questions, etc. I'm going to teach it live. And it will be in a classroom style. So you will be able to like ask questions and stuff a little bit easier versus this webinar style where you can't do that so easily. So 25 live classes, and I'm going to go through topic by topic and walk you through questions, show you patterns, show you how they trip you up with the MBEs topic by topic. So we're going to actually be going through questions. It's really going to be deeper than you ever have. It's sort of, if I wanted, it's like I designed my like dream class. If I were a bar taker, what would it look like for the MBE? Same with the MEE, 12 live classes, one class per subject, essentially, where I'm going to walk through 2 essays. There's also lectures you should watch in advance of class. A few on like how to write the analysis, how to like organize your answer, and some other stuff as well. There's like a little mini overview of each subject as well. And then in the live session, you're going to have come to class having written 2 essays, and I'm going to walk through it and show you really like how do you write an answer that is just passing? How do you beef it up to get a better answer, etc. And then also with the Mastering the MPT, there's 10 on-demand lectures. There's a ton on Mastering the MEE too. And then there's 6 live classes too, or like all of the live stuff we call boot camp sessions, so that you can join and really like we're putting you through that work. All of it, there's a ton of essays and PTs with model answer. There's a daily study schedule, just everything you could possibly need, all the MBEs, etc. And it's $16.99, so it's less than most bar prep. And you get all that like accountability and the how. So I'm super excited about it. So that being said, these are just some common questions that I always get asked. So talking about the MBE score. So people were encouraged because the MBE score was higher than it has been. It's the highest since 2013, but it's also not a huge shift. I think it's higher by like 0.6 points. So I think it was like 139.6 before, I'm sorry, 141.6, can't do math. And now it's 142.4. So it's not a huge shift. People like to make a big thing out of it, but it's not that big. That's also like the national average for the MBE. That actually does seem high to me. 142.4 is pretty solid. Scores, people always talk about, and people always ask me, okay, well, is February harder than July because February has lower pass rates? One exam is not harder or easier than the other. They literally make sure of that by doing the scaling and the equating to make sure that every exam administration is equally difficult. Just in terms of like, what does it take to get to the passing score for your jurisdiction? It's also just a really different pool of people. It's different circumstances that take February. It's a much smaller group. And people are facing different challenges when they're taking in February because they're usually retaking. So it just looks different. You also people make the same mistakes. And like some of those mistakes that people make when they're repeating is they think, oh, all right, I really didn't do well on the MBE. I just need to fix that. And they focus on that and they bring that up, but then the other stuff drops. And you really have to approach it. You need to know what your weaknesses are and absolutely address those, but you have to keep your strengths strong. So don't make that mistake where a lot of people that I see people do all the time. People always ask me, when should I start studying? You should literally be starting now. You do, if this was your first time taking it in July and you didn't pass it, it's something you do need to grieve. It's difficult. And I want to acknowledge that. It's really a tough thing. I hate having the chat off, so I'm going to turn it back on. But it's really a difficult thing. And so I just want you to know that, and you may need some time to sort of process that and grieve it. And it is something that you do need to grieve. I strongly believe that. And we also need you to get back starting studying. So you should start studying now or as soon as you possibly can. The last thing you want is to get to be 1 point away and be like, God, if I would have just started 2 days earlier, would I have passed? You don't want that running in the back of your mind. Also, if your jurisdiction doesn't automatically provide you with your essays and PTs from the exam, get them. So I know with New York, you have to literally mail a check or something weird, or mail a form. It's so arcane. It's not just a form online. But get your essays and get your PTs if possible, so that way, especially if you want to do a strategy session, or if you're working with someone one-on-one, or maybe you go to your law school and they can help look at your essays and PTs and say, okay, this is what you did wrong, or this is what you needed to fix. This is why you got these scores, and here's how to fix it. That's what we do a lot of. So those can be really, really helpful if you can get them from your jurisdiction. Not everybody provides them, but it's helpful if you can. So I just wanted to answer some of those really common questions first. All right, let's dig into it. I'm going to get the essays pulled up here. And I'm just grabbing these from the NCBE website. Okay. All right. So the first essay, and I'm gonna talk through it or read through it. So um, here it says, Lynn and Bo are chemists. Over the course of 2 years working together, they invented a new kind of antibacterial soap um, that reduces bacteria on skin for much longer than ordinary antibacterial soap. They shared ownership of the soap formula equally. So it looks like they kind of have a partnership, but that's going to evolve. We'll see. Lynn and Bo agreed to start a business to manufacture, distribute, and sell their antibacterial soap. First, they formed a limited liability company, an LLC, in State A, which has enacted the current version of RULCA, so the RULLCA. Lynn and Bo did not enter into a written operating agreement for the LLC, which means that the default rules will apply. Yeah. So, and did not discuss altering any of the default rules for limited liability companies. After forming the LLC, they contributed their soap formula to it. They agreed that the formula was worth $20,000 at the time of their contribution. Bo also contributed $5,000 to the LLC, which the LLC used to buy soap ingredients and advertise its products. So Bo contributes a little bit more, and Bo's going to be entitled to a repayment of that. During the LLC's first year of operations, Bo contributed an additional $2,000 to it. So Bo's going to be entitled to get that returned as well. After this contribution, neither Lynn nor Bo made any other contributions to the LLC. During its first 2 years of operations, the LLC made a total profit of $5,000. Through the end of the second year of its operations, the LLC made no distributions to Lynn or Bo. At the start of its third year of operations, the LLC had $5,000 in cash, the proprietary soap formula now worth $40,000, supplies worth $1,000, and no debt, which is great. At that point, Lynn and Bo disagreed about the company's direction. Lynn did not want to expand the business beyond soap. Bo wanted to expand the business into other consumer products. Lynn and Bo are at an impasse about whether to expand the business. So now we get into the calls. Whose preference will prevail? Lynn's preference not to expand the business into other products or Bo's preference to expand the business? Explain. 2, if the parties agree to dissolve the LLC, how would the LLC distribute its assets between Lynn and Bo? Explain. 3, if the parties do not agree to dissolve the LLC and one party seeks judicial dissolution, is a court likely to order a dissolution? Oh, that's it. For some reason, I was thinking it was the fourth question. So let's talk about this one. So one, I think that this question was, if you know these rules, I mean, that's the case, I think, with anything, then it's not bad. But also, like, these issues haven't been tested a whole bunch, at least the first issue. So that, I think, could throw people off a little bit. So whose preference regarding the expansion will prevail? And this here, even if you didn't know the issue, even if you didn't know the issue, I think common sense can sort of dictate an answer here. And if you just know how to make up a rule, which is something I teach in my writing classes, that can help. So here, but the answer is Lynn's preference not to expand will prevail because there has to be a majority to make a change, and there isn't a majority here. So we're going to just maintain the status quo. So that's why Lynn wants to keep the status quo, doesn't want to expand. So Lynn's preference will prevail on this one. And this would just be a really short little answer. 2, if the parties agree to dissolve the LLC, how will the assets be distributed? So they're going to be liquidated and applied to repay members for their respective capital contributions. So Lynn's going to get 10K and Bo's going to get 17K. So each of their capital contributions, and Bo had given more. And then the remaining 19K is going to be split evenly. So here you have to do a little bit of math. It's pretty easy, straightforward math. So that's how it's going to work. So 10K initial contribution, 17K initial contribution, 19K, they're going to split. So it's going to be 9.5 each. And if the parties do not agree to dissolve and one party seeks judicial dissolution, is a court likely to order it? And just generally speaking, a court does not like to order judicial dissolution, and the court won't do it here, so long as the business can reasonably carry on in accord with their informal implied operating agreement. And nothing suggests that they can't. It doesn't seem like there's anything where they're getting along or where they're really not getting along. So it seems like the business can continue. So a court will not grant a judicial dissolution, most likely. You could probably argue that they would in this case. I think you could come to a different conclusion here and be totally okay, though. Does that make sense? So fairly straightforward question. I think they love testing business associations, so this wasn't a surprise to me to be on the exam at all. So I hope it didn't surprise you either. We don't see LLCs so much, but you know, it's often enough that you got to be ready for it. All right, let's look at question 2. Okay, and this is a long one, contracts. Okay. So Pete lives in the northern United States. In the winter months, he earns his living by clearing snow from driveways and parking lots. One morning, following a particularly heavy snowfall, Debbie contacted Pete and asked him to come to her residence and clear the snow from her driveway. Debbie was not a regular customer of Pete's. They had the following exchange via email. So not a regular customer, so she wouldn't know certain things. So Debbie, hi Pete, can you come to my house and clear the snow from my driveway? I live at 10 Arbor Lane right here in town. What would you charge? Pete, I'm pretty busy today clearing snow for all my regular customers. I'm not sure I could get to you at all today, but if things go well, I could be there around 4 p.m. I charge $300 for a normal sized driveway. Debbie, well, I have a plane to catch tonight and I must leave the house by 5 p.m. I'm desperate. If you can get the snow cleared from my driveway before 5 p.m., I'll pay a premium price of $500. Pete, I will do my best, but I can't make any promises. Is that an acceptance of her offer? No, right? He said, I'll do my best, but he literally said, I can't make any promises. Pete worked extra hard and fast that day to finish clearing snow for his regular customers. To further ensure that he got to Debbie's house in time to get her driveway cleared by 5 p.m., he passed up an opportunity to clear a parking lot for $400. So there might be some promissory estoppel here, some reliance. He was able to finish all his work for regular customers by 3:30, which left him plenty of time to get to Debbie's house and clear her driveway. However, when Pete arrived at Debbie's house at 4 p.m., he saw that her driveway had already been cleared. So what does that tell us? That's an informal or an indirect revocation because she had somebody else do the work. And he knows that before he actually accepts. So Pete left his truck, went to the front door of Debbie's house and rang the doorbell. When Debbie appeared, he said, I'm Pete. I accept your offer to clear your driveway. Is this a valid acceptance? It's not a valid acceptance, right? And this is something you have to really get familiar with, especially on the MBEs. Sometimes somebody will say, I accept your offer, and you have to ask yourself, is that a valid acceptance? Or when somebody revokes an offer, you have to ask, is that a valid revocation? So again, organizing contracts essays can be a little tricky. Here they obviously give you some detailed calls, but you really want to know how to think through an entire contract essay and go through it chronologically. Okay, so I accept your offer to clear your driveway. I'll get started right away. Debbie said, sorry, someone came by and offered to do the job for $300, so I paid him to do it. As you can see, it's already done. Pete replied, I still want my $500. Debbie told Pete that she owed him nothing and she shut the door. Pete believes that, in light of the email exchange with Debbie, the fact that he passed up the opportunity to clear the parking lot and the fact that he showed up at Debbie's house in time to clear her driveway by 5 p.m., he was entitled to clear Debbie's driveway and be paid $500. So, questions. Did the exchange of emails form a contract? Explain. When Pete traveled to Debbie's house and said to her, I accept your offer to clear your driveway, did that form a contract? So we're really just dealing with the formation essays with the first two. 3, assuming that no contract was formed under question 1 or 2, does Pete have a claim based on his reliance on Debbie's statement that she would pay a premium price of $500 if he cleared the snow from her driveway by 5 p.m.? And 4, assuming he has a valid claim under 3, how much can he recover? So we have contract formation and promissory estoppel, reliance, essentially, and remedies. So what can you recover under that? So going through, and I think SA1, and let me know what you guys think in the chat too. But I thought SA1 was pretty straightforward. I think this one is also pretty straightforward. So starting off, a little light, but you could easily, because these are long, go over in time. And that's the problem. So you've got to know, and we show you this in our courses, how to finish these in time. And that way you can push through to the rest. Because there's going to be an essay in here that throws you off with an issue that you just don't know. Almost every bar exam, we basically see something they haven't tested before. So you want to be really ready for that. So, and can you guys, let's see. Yeah. Okay. Oops. So did the exchange of emails form a contract? So here, no, it didn't, because Pete did not accept Dee's offer because he literally said, I can't make any promises. So the email exchange didn't form a contract. Then when Pete traveled to the house, did that form? And again, that's no, because the offer had been indirectly revoked by having someone else clear it beforehand. And then call 3. And obviously you would have rules in here. I want people to know what they needed to say here. And as long as you had your analysis addressing these things at a minimum, you could get a passing answer. So I try to just keep it a little tighter in here. So assuming no contract is formed, does P have a claim based on reliance? So it's debatable whether P can use reliance, right? So he did rely, but the question is was his reliance reasonable? And you would really want to argue both sides here. So he does rely on it because he passed up another job to complete Debbie's job. But again, like I just said, it's debatable whether it was reasonable. D offered a premium to have P do the work. So she made him a pretty good offer. And she needed the work done by 5, but P couldn't promise to do it. So was it reasonable to rely and just show up and just skip a job? Should he have checked in or done something else? Probably. Because she's in a tight spot. She's got to be able to get out of her driveway before 5 p.m. So she needs to know that someone's going to do it. And then 4, assuming P has a valid reliance claim, how much could he recover? So the reliance loss would be at least $400. So the job that he lost, that somebody called, the job that he turned down. You could argue, and it really doesn't matter which way you would come to, but you could argue that it could also be 500, the amount that he was supposed to get from doing hers. So yeah, you would want to just argue both or talk about both as possibilities. So when you can see here, calls 1 and 2, pretty straightforward. There's not a lot of factual information that I need to put in there. There's no ambiguity. But calls 3 and 4, there's some ambiguity that you need to deal with. And there's just more to kind of get into. There's more facts, which means those are bigger issues and you need to spend a little bit more time there. So you have to really know how to approach essays and identify where there are more points, essentially. So, all right. Somebody said essay 1 was tough. They didn't have enough notes on LLCs, but contrasts. Yeah, and that's what I think for a lot of people on the LLC. Somebody asked for the contracts essay if there was an argument about a unilateral contract. No, it's not something you need to get into. It doesn't have an impact at all here. Okay. Now trusts and future interests. I think people were maybe not expecting this so much. So, all right, let's talk about this one. So Testator was born in 1880 in a rural area of State A. At the age of 5, he was enrolled in the local one-room schoolhouse and remained in there until he graduated at age 18. There were no more than 30 students in the school at any one time. All 4 students in Testator's graduating class attended State A University. In 1902, Testator graduated from State A University with a degree in business. Over the next 20 years, he was extremely successful financially. In 1922, Testator died, leaving a substantial estate. He had never married and had no children. His closest, God, he died young, 42. Geez, that's my age. In 1922, Testator died, leaving a substantial estate. He had never married, had no children. His closest living relative at his death was his first cousin, with whom he'd had little contact since his childhood. Under his probated will, he's so put together that he has a will at 42. Testator bequeathed a total of $500,000 to several art museums throughout the United States, $250,000 to Capital City Concert Hall, and $1.75 million to the Business College at State A University. He bequeathed the balance of his estate, $2.5 million, this is pretty good in 1922, Lord, to a valid perpetual charitable trust with Bank X and State A named as trustees. Anybody else thinking though that like the Great Depression is coming and he's probably going to anyways lose some of this in the stock market? Under the terms of the trust, all trust income was distributable annually to pay the education expenses of any persons as selected by the trustee who had graduated from a one-room schoolhouse in State A and were attending State A University while under the age of 25. For many years, the trustee had no difficulty identifying potential beneficiaries under the terms of the trust. Over time, however, there was a substantial decrease in the number of students graduating from one-room schoolhouses in State A. By 2010, there were no such students attending State A University, and the remaining one-room schoolhouse in State A permanently closed. There are now no longer any persons to whom the trustee can distribute trust income in accordance with the terms of the trust. The value of the trust assets is $10 million, earning roughly $500,000 of trust income annually. That's accurate. Bank X would like to resign as trustee and recommends that a court appoint Bank Y as trustee. Bank Y is a reputable bank with extensive experience in trust administration and is willing to assume the trusteeship, but only if the terms of the trust are modified to allow it to distribute trust income to graduates of any rural public high school in State A attending State A University. Fred, the closest relative of testator now living, and the sole surviving descendant of testator's first cousin, believes that the trust can no longer continue and should be terminated, and that the principal should therefore be distributed to him. Of course, Fred thinks that. State A, oh, hey, Mindy. State A has adopted the Uniform Trust Code. There are no other applicable statutes. So now we get into the questions. Does Bank X need judicial approval to resign as trustee? Explain. Does Fred have any interest in the trust? Explain. Can the trust terms be judicially modified? Explain. Cypre, you can do that. Assuming that Bank Y has been appointed trustee and that the trust terms can be judicially modified, between the suggestions offered by Bank Y and Capital City Concert Hall, which suggestion would a court be more likely to adopt? All right, so let's go through this. So does Bank X need judicial approval to resign as trustee? Yeah, you do need judicial approval to resign as trustee in this case, because they've been appointed, et cetera. There's just straight rule on this. If you want to resign as trustee, you do need to get court approval. Does F have any interest in the trust? No, F doesn't have any interest in the trust because the trust can be modified in a manner consistent with the charitable purpose here. So F doesn't have any interest in the trust. But I guess, you could talk about that if they couldn't modify it and the trusts were terminated, then theoretically via intestacy, it could go to him, but that won't happen because it can be modified. So can the trust terms be judicially modified? Yes, under the Cypre power, because the purpose of the trust has become impossible or impracticable. So if we look at these, we want to distribute income to graduates of any rural public high school attending State A University. And yes, that's different. The trust purpose is to pay for and, assist people attending State A University. But if that just isn't happening anymore, we still probably want to serve and help that same kind of group of people. So we can do that by switching to the rural public high school. That would probably be in line with the testator's intent, and you would want to use these facts from the beginning. The fact that he, at the age of 5, he was enrolled in the local one-room schoolhouse, remained there until he graduated at age 18. So it just looks like he wants to give back to those, in that community. So it makes total sense to modify to give pursuant to the give to the graduates of the high school, which is who wants. And you would do that as between the the suggestions offered by Bank Y and Capital City Concert Hall. So Capital City Concert Hall, they were just given a straight gift. Um, they were given a straight gift of the 250,000 to the concert hall, and it really looks like you've got to take and really decipher the testator's intent here. So really getting in and using all the facts in these paragraphs. The fact that, why should they modify to give to Capital City Concert Hall when they're not considered at all in the valid perpetual charitable trust? And the charitable trust is supposed to go to those students. So it's going to be done in line with, only in line with what Bank Y states. I know there's some questions coming in the Q&A, and I will definitely get to those. There's some good questions there. So rolling right along into question 4. So I think this question, threw people. And I think really you've got to use the facts in this. And you could kind of get into it a bit here, and really using the facts to show why should the court modify, doesn't make sense, etc. And, sort of discerning the testator's intent. Okay. How many of you were thrown off by con law? One, they don't test con law all that often on the MEE. But they're going to be testing it more, just FYI. So one thing that, maybe people don't know is that, and somebody mentioned this in one of the questions, so wills and trusts, secure transaction, and family law are still testable on the February 2025 exam. And then between July 26 and July 28, it will not be tested on the MEE. So those subjects are going away, and conflicts are going away. So then when the exam switches over to next gen in 2028, so for 2026 to 2028, the PTs will test, I think, on wills and trusts and family law. And then in July 28, effective then, I believe those are going back into the essay subjects, and PTs will cover a range. So it's going to be, next gen's going to be a little interesting. And the time leading up to next gen is also going to be interesting. And I think a little bit easier, which is, starting in July, not February, it's still the same old thing. And then in July, it's a little bit easier. All right, let's talk about this con law question. Oh, I didn't give a prediction for February 2026. I just said everything is still on the table for February 26. All right. So this gets into some minutia of con law that I think people didn't know and didn't expect. All right. Last year, Congress passed the Economic Incentive Act, which the president signed into law. The preamble of the act states that it was passed pursuant to Congress's power to regulate interstate commerce. That's really key, and that gets to a thing that, honestly, a lot of people don't know. When I saw that, I was like, ooh, I felt bad for all y'all. And no legislative history indicates any other purpose. The act contains 2 substantive provisions. And this is where, like somebody said in the chat, they skipped this essay entirely, hence they're retaking it. You can't do that. You have to know, what do you do when you get the essay where you're just like, oh no, right? When you get that oh no essay, you might pick a better word instead of oh no. You've got to know what to do to handle that. In my final forecast class, I talk about that and like how to really break down a fact pattern and what to do so that you don't walk out having skipped one, because that's just not going to go well. All right, so it contains 2 substantive provisions. So we're going to have questions about each, and you need to break down the facts as they relate to each. So I'll break down this one a little bit. First, the notice provision prohibits any employer with more than 100 employees from terminating an employee's employment without cause on less than 30 days notice. So that applies broadly to everybody. So it applies to private persons. And so, it can apply to the state as well. The notice provision states that it applies to employees of both private businesses and state and local governments. Okay, good. Second, the housing provision of the Act creates a federal program that provides grants to private developers of new low-income housing projects meeting the Act's requirements. The housing provision directs designated municipalities to administer this federal grant program by accepting applications for grants, reviewing the applications, making decisions, and enforcing the Act's requirements. The housing provision authorizes the United States to impose monetary penalties on a municipality that does not administer the grant program. The last section of the act provides, and anytime they give you a quote like this, it's obviously going to be extra important. So you're going to want to make sure that you use those facts. So any person who is harmed by the failure of any state or municipality to adhere to any provision of this act may recover actual damages suffered as a result of that failure and may bring an action to recover those damages in federal court. Okay, so that's really key. A state or municipality shall not be immune, so getting at immunity, so sovereign immunity, under the U.S. Constitution from suit in federal court under the act. All right, but there's like some technicalities, right? Just because they say this, you can't assume that this is constitutional, which is what they get at here. So a man worked for state A, which employs more than 100 people, and a woman worked for city, a municipality in state A, which employs more than 100 people. So they are subject to these provisions. State A and city recently terminated the employment of the man and the woman due to budget cuts. The man and the woman each received only 1 week's notice from their employer, so there's a violation. The man and the woman have filed separate lawsuits in federal district court against state A and city, seeking damages for violations of the notice provision of the act. In the suits against them, state A and city have each moved to dismiss on 2 grounds. 1, sovereign immunity recognized by the U.S. Constitution bars the lawsuits, and 2, the notice provision of the act commandeers state and local governments in violation of the 10th Amendment. No provision of state A law indicates that state A consents to lawsuits in federal court. County is a municipality in state A that has refused to accept grant applications for federal funding as required by the housing provision of the act. The U.S., therefore, recently applied that provision to impose a substantial monetary penalty on county. County has filed a federal lawsuit seeking a declaration that the housing provision of the act is unconstitutional because it commandeers municipalities in violation of the 10th Amendment. So, does sovereign immunity bar the man's lawsuit against state A? Explain. Does sovereign immunity bar the woman's lawsuit against city? Explain. Does the notice provision of the act commandeer state A in violation of the 10th Amendment? Explain. And does the housing provision commandeer county in violation of the 10th Amendment? All right. So again, these, you really did have to know the law a little bit deeply here. And this is common law. And I think a lot of people just didn't know it deeply enough for these particular issues. So does sovereign immunity bar the man's lawsuit against state A? Yes, because the state may not be sued by citizens from another state. There's no exception that applies. And the law accepts states from sovereign immunity, but that only applies. So like this particular law only applies. This particular law says that it grants an exception for sovereign immunity, the way that the statute and the fact pattern is given. But that only applies generally to enforce the 14th Amendment. So, and here it's to enforce the Commerce Clause. So there isn't, so sovereign immunity does bar the lawsuit here, and that's tricky. And then does sovereign immunity bar the woman's lawsuit against city? No, because cities, municipalities don't have the same protection as states. So it doesn't bar that suit. And then does the notice provision commandeer state A in violation of the 10th Amendment? And it doesn't in this case, because the 10th Amendment bars Congress from using state actors to administer private behavior. But Congress can require states to comply with the same laws. So here, because the law applies to private persons, they can then require enforcement by the state officials as well. And then with number 4, here, this doesn't apply to private persons. So the housing provision requires county to administer a federal law under threat of financial penalty. So there's that. So you have to really know the differences between commandeering and sovereign immunity. And, I think people know a lot of the individual rights pretty well, speech, commerce, etc. But this is really getting at some things that I think and we just haven't seen tested as much. So I think this ended up being tricky. How many of you guys found this essay pretty tricky, or just sort of like a shocker? You can tell me in the chat. And also just a note that this question was not triggering the spending clause. I think a lot of people think, okay, well, is it a penalty, or is it, just, what is it? with a spending clause, but that doesn't apply here because they're literally asking about the commandeering provision, not spending. So this is like if people talked about spending, you were off track. Yeah. So I definitely thought this was a tougher essay for a lot of people. I would have not been happy answering that either, truthfully. Okay, let's get into this one is criminal procedure, essay 5. Again, this one I thought was a little bit more straightforward. So we have a public high school in city, state A, has a rule that prohibits students from going to the gas station across the street from the school during school hours because the police have identified that gas station as a site of frequent drug dealing. The school includes the rule in the student handbook that the school provides to all students and their parents at the beginning of each school year. The school's principal also orally informs all students of the rule. On October 10th at 2:30 p.m., during the last class of the day, the school principal looked out a window of the school building and observed a student walking from the school toward the gas station across the street, so violating the rule. Once at the gas station, the student walked close to a car, talked to the driver through the open driver's side window, and handed something to the driver, which this looks super shady, right? The principal could not see whether the student took anything from the driver, so you could have like a little counter argument around that. But after the car drove away, the principal saw the student put his hands in the front pockets of the jacket he was wearing. So there's, the principal, even though he's at a public high school, there's different expectations of privacy when you're a student at a high school. And then this particular, does this give, does this scenario give reasonable suspicion to the principal to conduct a search? Absolutely here. The student returned to the school. About 10 minutes later, the principal ordered the student into the principal's office. When the student arrived, the principal reached into the front pockets of the student's jacket, which he was still wearing, and removed three $20 bills and a small clear plastic bag containing 2 white pills. As set forth in the student handbook, possession of any kind of medication in school is prohibited unless permission has been given by the school. The student did not have the school's permission to possess any medication. The principal informed the student that the money would be returned to him if it was not connected with the crime. The principal told the student to return to class. The principal decided to then search the student's assigned locker. So first one, pretty obviously, does it violate the Fourth Amendment? No, there's reasonable grounds to search the student. There's known drug dealings, etc. And this is like in a public school environment, there's lesser expectation of privacy, etc. And it's a principal. As long as it's not the cops coming or it's not the cops telling the principal to do it, it's this lower standard here for school safety. But now let's look. And so I think the first part is pretty cut and dry. Principal decided to search the student's assigned locker. This is getting a little trickier. The school's locker policy provides that lockers are the property of the local public school district, that an assigned locker may be searched at any time, and that the school administration has a master key to all lockers. This policy is written in the student handbook. In addition, on the outside of every locker is a sticker stating this locker is the property of LPSD and may be subject to search. The principal unlocked the student's assigned locker with the master key. On the locker's top shelf was a clear plastic bottle containing white pills that appeared to be identical to the pills found in the student's jacket pocket. There was also a small clear plastic bag containing a green leafy material that looked and smelled like marijuana, possession of which is a crime in State A. The principal confiscated both the bottle of pills and the plastic bag of leafy materials. Long fact pattern here, which is common, so you got to get used to it. The principal phoned city police. An officer arrived at the school and took into custody the items seized by the principal from the student and the locker. Chemical testing of these items determined that the white pills were methamphetamine and the leafy material was marijuana. That evening, police obtained a valid warrant to arrest the student for possession of controlled substances in violation of state aid law. So, and notice that this is an arrest warrant, not a search warrant, right? So different. With an arrest warrant, what can you search? Right? You can do a search incident to lawful arrest. The next day, 2 city police officers arrived at the school during the school day and arrested the student who was wearing his backpack. The officers searched the student and his backpack, from which an officer removed the student's unlocked cell phone. which just everybody, you guys know that you should have Face ID turned off on your phone now so they can't hold it up to you and have it unlocked. Just throwing that out there. Especially if you're traveling internationally. So little extra tip. Um, One of the officers looked through the phone's text messages and found a series of messages that set meeting times and places and listed number of units and cost. A message from 10 a.m. on October 10th referred to a meeting in the gas station parking lot at 2:35 p.m. and mentioned a cost of $60. State A charged the student with possession of controlled substances. Did the principal search of the student's jacket pocket violate Fourth Amendment, the locker, and then the text messages? So first, there's state action. It's public. He's a principal. He's, state employee. But here, there's not a violation for the jacket pockets because there's reasonable grounds to search the student's pockets based on the principal's observations. And the search was reasonable given the known drug dealing at the gas station. So number two, did the principal search violate the Fourth Amendment? The student did not have a reasonable expectation of privacy, so it doesn't violate the Fourth Amendment. And you would use all the facts about the locker policy, that it's in the handbook, the policy is written in the handbook. On every locker, there's a sticker stating that. So you don't have a reasonable expectation of privacy because of all those notices. You really have to use the facts here. I mean, you have to always use the facts everywhere, but I'm just showing you also in the fact pattern, like what you would have relied on there, what facts you should have talked about. So because of all of those facts, there is no reasonable expectation of privacy and therefore no violation of the Fourth Amendment. But did the principal's search of the student's text messages violate? Yes. The warrant was an arrest warrant, so you really need to hit that point. That it doesn't allow for a search warrant to search for any evidence of that, so that wouldn't let you go into the phone. So a search incident to lawful arrest applies, but that extends, and remember the policy behind SELA is for officer safety. So going through a cell phone has nothing to do with officer safety. So yes, that search violated the Fourth Amendment. So I think this essay is, again, fairly straightforward. You've got to manage your time and you want to use the facts. You've got to use the facts with every single one, but to show why there's no reasonable expectation of privacy. And time management is really what makes this exam just so difficult in general. So, all right, y'all ready to talk about the last essay? Torts. Oops. And then we'll talk about the PTs a little bit. Okay. All right. So after a homeowner's curbside mailbox was damaged, the homeowner phoned Quick Mailboxes, a small corporation that installs and repairs mailboxes. The homeowner told the Quick Mailboxes receptionist, "I don't care how you fix it, I just want it done by the end of the week." The receptionist said that the company would charge $220 for the repair, and the homeowner agreed to hire Quick Mailboxes to perform the job. Quick Mailboxes has 10 local employees. It conducts background checks on all its employees, verifies that they have appropriate driver's licenses, and trains them as needed. After receiving the homeowner's call, Quick Mailboxes promptly sent Jane, one of its part-time employees, from its main office to the homeowner's property to perform the repair. So this is an employee, right? Jane works 20 hours each week for Quick Mailboxes. She drives to work sites in a small old pickup truck owned by Quick Mailboxes. So acting within the scope of her employment, she's driving the truck. She works there part-time. All right. When Jane arrived at the homeowner's address, she stopped the pickup truck along the curb on the hilly street so that she could survey the mailbox's damage from her window. As she was about to exit the truck, she answered a personal call on her cell phone. So this is a personal call. So then there's going to become an issue of, is she acting within the scope of her employment? But she's still in the truck, and the call lasted about 3 minutes. So it's a really short call. That's not going to take you outside the scope of acting as an employee, but you need to address it. There's some controversy here. In torts, there's almost always some sort of counter argument to address. In most essays, there's something that you can find. Distracted by the call, so, and again, that call that was not within her scope of employment, but it's still a frolic, not a detour. So Jane left the truck without shifting it into park and did not engage the parking brake before she walked to the homeowner's front door to introduce herself and explain the work she planned to perform. So, causing some damage here. While Jane and the homeowner were talking at the front door, the Quick Mailboxes truck began rolling down the street. The homeowner saw it and stared in surprise, but said nothing. They don't have to say anything. Seconds later, the truck rolled partly off the pavement into a street sign. The post holding the street sign collapsed, sending the sign crashing onto a vintage luxury car worth $430,000 that a neighbor had parked on the street. I don't know why you're parking that car on the street, but that's whatever. We don't have to get into that. The neighbor had the car repaired. Because of the special parts needed and the difficulty of finding them, the repairs cost $55,000. It's like eggshell plaintiff, right? It's weird to see it applied to a car, but it still applies. The neighbor also suffered serious emotional harm requiring medical attention because he had happened to look out his living room window just as a sign fell and damaged his car, which had significant sentimental value to him. Can he get emotional distress for that? No, you can't. So it's really getting at like NIED. So is Jane directly liable to the neighbor in a negligence accident? Explain. If Quick Mailbox is liable to the neighbor directly or vicariously, you've got to answer both. Not directly liable, they are vicariously liable. We'll get into that. Is a homeowner liable because the homeowner hired Quick Mailboxes? Talk about that. And then assuming that any of the parties is liable, can the neighbor recover the cost to repair the car, even though they were unusually expensive? Yes. And again, assuming that any of the parties is liable, can the neighbor recover damages for emotional harm? No. So just quickly, is Jane directly liable to the neighbor in a negligence action? Yes, because if Jane had a duty to behave reasonably and Jane breached that duty. So a quick little negligence analysis, really straightforward here. Is Quick Mailbox is liable to the neighbor directly or vicariously? So yes, they're vicariously liable because Jane was an employee acting within the scope of her employment. Counter argument, yes, she was on a personal call, but that's normal because it's so normal for people to take a quick call. It was just 3 minutes. We're going to say that probably amounts to her to just being a small frolic, not a detour. And it's such a common thing that people do. So, but you're going to have to address that counter argument. Also, the fact that she was so distracted, which is what caused it. So it really was that personal call interfering. So you would have to really deal with that counter argument, a little bit of ambiguity there. And Quick Mailboxes is not directly liable because it did not act negligently in its hiring of Jane. So vicariously liable, yes, not directly liable because they weren't negligent. Had they done something like, not check, maybe Jane has lots of texting while driving or talking on a cell phone while driving, tickets, maybe then there would be some liability, but they didn't do anything like that here. And somebody asked if you can rack up points with these short type of answers. These are just sort of my notes. You would want to definitely these are just sort of my bullet points for these of what you needed to address, the conclusions you should have come to if there was a counter argument. You would want to develop these more with the specific facts from the fact pattern. And in my classes, I can show you, I do get into when we practice writing essays, like where to kind of go cut. What do you do when you're running out of time? All of that stuff we cover heavily in my classes. So is the homeowner liable to the neighbor because the homeowner hired Quick Mailboxes? No, they're not, because the homeowner is not an employer. So they're not, did I say, I think a frolic. Did I switch those words around? I think it's a frolic, right? Not a detour. The detour is when you're not acting within the scope. Right. She was acting within the scope. So I think it's like a minor thing. It's a frolic. Yeah, frolic. Okay. Can the neighbor recover the cost to repair the car? Yeah, you can recover. The eggshell plaintiff rule applies still. It's as long as damage is foreseeable, it doesn't matter the extent of the damage or the severity of it, it's still recoverable. So that was it foreseeable that the damages could result? Absolutely. Can the neighbor recover for the emotional harm though? No. And there's numerous different NIED scenarios, and they're really trying to make it look like a bystander theory, but it's your car, not a person. So it doesn't matter that it was very sentimental to you. You cannot recover for the emotional harm. There's no NIED theory that would work in this case. So they weren't in the zone of danger. It's not the bystander theory, and it's not one of those other unique scenarios that trigger emotional, where you can recover for emotional harm, absent physical injury. All right. So that's it on the essays. Let me talk about the PTs now for just a minute. All right. So there was obviously the two PTs. So the first one was Lowe v. Jost. Um, and I have to say the thing that I want to say about these two PTs, it's on the bottom here, but with these PTs, and I think just performance tests in general, you have got to be so good at knowing how to get through that material and know how to extract the rules, how to make decisions on what you're going to include, what you're going to cut, how to draft, what I call a rule proof to analogize to or distinguish from a case in the library if you're going to do that, which you will generally be doing. How to organize, all of those things. You've got to have that stuff down cold. PTs are really important. They can tank you and they can also really carry you. So if you're scared of the essays because you're like, what are they going to give me? And they're going to give me some point of law that you don't know, which will happen. Then you want to really know how to just crush your PT. And we absolutely, I mean, like, I think, I'm pretty well known for the PT. In this one, I think these two really put that on display for me. I really noticed that. So Lowe v. Jost, persuasive, it's a brief. You would organize by the argument given. The arguments were given to you. They said not to do a statement of facts, but there is a lot to cover here. And I also thought that like some of the arguments you had to come up with, like, and this is where you need to save yourself the time. You need to be so good at getting through, oh, hey, Jade, at getting through the PTs such that you can actually have time to think and come up with arguments that I thought weren't super obvious. So let's walk through it a little bit. So you would have your introduction, you would have your argument section, and I have a third section on the next slide. So first, talk about Dr. Schulman being a qualified expert. That's our expert. So the rules you're going to use are 702 and Smith. And he's qualified based on experience, right? But there's a counter argument here. So he hasn't practiced in Franklin, hasn't practiced since 2019, but that's okay. Like you can take, all of the facts there, but the other side is going to raise that they haven't practiced in Franklin and haven't practiced for a while, but they are still like up on the literature and teaching and just doing all sorts of stuff. So definitely qualified. You can absolutely make that argument, but there is a decent counter argument to be made there. Point two, Dr. Ajax is not a qualified expert, so this is the opposing expert. And even if he is, so there's two parts to this second one. Even if he is, the court should exclude all proffered opinion testimony. Again, 702 and Smith. So why is he not qualified? He doesn't specialize in hip replacement. That's a weak argument, something you could raise. The bigger thing is in qualifying someone as an expert, you have to show that their opinion is based on reliable methods. And this is the part that I think was tougher to come up with. And you have to look at the testimony and say, okay, well, he doesn't describe the methods or sources that form the basis of his opinion. So that was a bit tougher to see. The other thing, though, is he doesn't provide, all he says in his opinion is he should have gotten another x-ray to see whether there was a problem here. He doesn't actually opine as to whether there was a break in the femur or a misplacement of those in the surgery that could have been detected from another x-ray. So his proffered opinion is just essentially speculative. And then we've got to argue an MSJ, basically, that Jost, the doctor, our client, is entitled to summary judgment because plaintiff has failed to offer any admissible evidence on some of the elements of the malpractice claim. So you're going to get FRCP 56 here, and then the Jacobs case. So Dr. Ajax based his opinion, this is the opposing side, the plaintiff, solely on unsupported medical evidence. They're not sufficiently reliable. So causation is contested here. So, it'd say, well, there's a genuine disputed material fact regarding causation, but like the plaintiff says it was caused by the surgery, we say that it wasn't. So that's in dispute. And there's a lot of rules on this. There's so much about MSJs and there's a lot that you could cut. So strategically, there was a lot of information that I would have cut here. But here, all that the plaintiff has offered is that Dr. Ajax just states that all they state is that they departed from a good and accepted medical practice in failing to order another x-ray, but doesn't offer anything about causation. So it's really just speculative testimony. So that's all that you had to do. And I saw so many people do And what I imagine happened, and this happens a lot, is people did well on MPT1 or had to take extra time to get through MPT1. And I've seen so many lower scores on MPT2, which is really common. I've already been meeting with people for the last few weeks and going over and doing strategy sessions, etc. All right, MPT2. This is an objective memo. You organize by thing, so by document. You start with a description of the legal standard, analyze whether each document is protected by attorney-client privilege. And they required a lot of specificity based on the task memo instructions. So like detail is important here. And there's some close calls. There's definitely some close calls. You can't be hyper vigilant. Generally, your client's going to get what they want. That is true. But they don't always get everything that they want, but they will achieve their overall goal. And we want to protect everything, right? We really want to keep this protected by attorney-client privilege. We don't want, a competitor to see any of our stuff, any of our details. So we really do want to protect our client here, but you also have your ethical duties to balance. So you have to be cautious not to be overzealous. So you would do the introduction. You would do a quick intro analysis. So what I would do is I would give all of the rules up here at the top. So rules, the value mark, the 5 factors, and talk about redacting the privileged portions. What can you do? And then you go through each of the documents. So document 1, the predominant purpose is legal. So that should have been entirely protected. And you want to just go through each paragraph, talk about it. Document 2, and this happens a lot where there's going to be one that's really obviously one way, one that's maybe obvious the other way, and then there's going to be one that's really a difficult call. So, 3 documents here, there's going to be different analysis for each. The document 2 is marked privileged and confidential, but that's not dispositive. This is a mixed doc, and I would say overall this document is probably not privileged, but you could absolutely still redact the last paragraph because it's legal. And then doc 3 is again a mixed document, so business and legal. And issue 1 was totally not privileged. They were just saying, how do I present this information? How do I present this information? And issue 2 could really go either way, but you could and should assert attorney-client privilege on that one to just be protected. Like you're in good faith, you can and should assert attorney-client privilege for the second one. I think that's all I wrote. Okay, yeah. So I'm going to get to the questions here as well. So just to kind of go through just a note on the PTs. I thought that these two, I didn't think it was difficult per se, like just to understand the concepts so much, but there was still just so much to get through that you needed to do. So that I think was a challenge that really requires it requires like efficacy and speed, which comes through practice. So many people put off PTs until late. Don't do that. Our core program, like I said, we had a schedule to start on November 1st. You can absolutely start on that and get caught up, easy peasy. We also will have a schedule that starts November 15th. So if you don't get caught up, you can switch over, but starting sooner is better. And there are assignments to do before class. The first live class is on the 17th and 18th. So let me get to the questions that are in the Q&A. So considering that so somebody said this, and this person, the first question, considering the score in July 25 increased around 10 points with respect to February 25, I would just say you can't really compare a February and a July. You have to know how to do it. So I'd have to really look at your score sheet. So schedule a strategy session with me. All right. Oh, thanks, Ashish. That's awesome. Somebody else said time management was a major issue, both the MEE and MPT. Yeah. So biggest way to counteract that is you have to practice under exam conditions. So closed note and timed. And it's not just saying, okay, 30 minutes is up and I'm done. It's knowing how to make strategic decisions when you're in the essay to finish it. And we absolutely talk about that in my classes. I'm really big on that. Like, I want to know, how do you just get to a passing answer, even when you don't have as much time as you wish you had, which is always the case. So that's huge. Somebody asked, how do you know how much time to spend? And it's really like with the process that we teach you for approaching the essays and the PT, you will see how much each essay should only be 30 minutes. You should never go more or less. you should never be more or less, but you will have to identify, not each question within an essay is worth the same amount of points. And it depends on the complexity of the question. How straightforward is it in terms of the answer? Does it have a lot of elements? How many facts are there for it? So I teach that in the classes too. So that's really knowing. It's not a quick answer, but it's absolutely discernible, and you see it by practicing it over time. Somebody said that they've heard that the formatting of PTs really matters. I mean, it does to a point, but there can be some variance in it. So yeah. Formatting is really important, but like your job on the bar exam for the essays and the PTs is to make it easy for the bar graders to see that you hit the issues and that you like use the right stuff in the right place on the PT, that you answered the questions, etc. So like paragraphing well and headings are your friend. And then somebody asked, is it possible to have a 40-point jump in February? Yeah, it is. I've seen people do it. Look, and that is a tough thing to do. It's a really difficult thing to do. I have seen people do it. So you should, if you have any questions, you should make an appointment. And I just want to say how excited I am about our classes that are starting for the February bar. If you really want to like that accountability piece, the way that I'm structuring my classes is more like when you were in law school, where there's stuff that you have to do. You show up having done your work, you come to class prepared, and where there's accountability for each week. So I'm really kind of building out like, what if I was a bar studier, what would I really, really want? And this is it. So it's a revamp of, I've done stuff similar to this previously, but this is like really breaking things down into bite-sized chunk for you as studiers to try to like reduce overwhelm that often happens. And somebody asked me, is 8 points doable from July to February? Yeah, that's totally doable. I've had people do that, I don't know, every day of the week. That easily happens. I've had people go from below a 260 to above a 290. I had somebody get like a 345 or something like that this exam. So it absolutely is doable. It's just really like you have to know the approach to take for you. You need to know what works for you. You need to have the time and just start. And like, you can't be afraid to write. You can't be afraid to do all of these things. People always tell me they don't know enough law yet. They don't have enough memorized. Just try. And in one of the podcast episodes, I think it's the 3rd episode, I talk about how to start writing even when you feel like you can't, how to start practicing essays. And yeah, somebody said perfection's the enemy of completion with the essays. They write too much. Yeah, I tutor. I do a lot of tutoring one-on-one. And that's like one of the biggest things is I'm showing people cut this, cut this, cut this, cut this. Just give me just like the basics. All right. And then somebody asked if advice for handwriters. It's really, you just have to practice handwriting a lot. And you have to be a bit more organized as you're planning out your answer, because you can't, when I type, I teach how to take the facts and put them in. So you can't do that when you're handwriting. So you just have to know which facts you're going to use where. Yeah. So if you haven't made an appointment with me, make that appointment. Somebody asked how many MPTs and MEEs do I recommend? I recommend a minimum of 8 MPTs, ideally more like 12 to 15, and definitely a few sessions where you do 2 back-to-back. One-on-one tutoring, yeah, I have started it with some people, but I do still have spots. I will be full in the next few weeks. But you can sign up. So if you want to do it for this bar cycle, it's better to sign up sooner, and then we'll schedule you accordingly, even if we don't schedule it for a little bit later. But you want to get signed up to reserve. I have a certain number of spots left. So I anticipate being full because California results come out this Friday. So I anticipate being full, but I have people that tutor for me too, and they're really, really good. So, and how many essays should you do per subject? Honestly, with the MEEs, like 15. I assign so much. So yeah, and I do schedule all of the tutoring in advance. So the way the tutoring works is you buy the tutoring, then you want to get the quantity that you want to do. And you should have a strategy session with me to talk about what I would recommend for you in terms of tutoring. how many sessions to do, what that schedule should look like, and then you buy it, and then we schedule all of it in advance. We have an intake where I give you assignments. Um, I give you assignments. We talk about what you need to work on. I take some notes on this stuff, and then we schedule everything. Somebody asked if you can do your tutoring with the bar prep program, or is my program meant to be taken solo? You can do a lot of people do my tutoring if they've already got something else. Yeah. And like, I would just say, any tutor you're thinking of working with, you should talk to and make sure that you jive with, and that like it's not tutoring if it's a class. Like, I don't do group tutoring is where you're meeting one-on-one. That person is looking through your work. They've ideally given you assignments in advance. They're going through your work. They're ripping it apart and showing you how to fix it. Um, yeah. So tutoring is, and it's a unique skill. Just because someone's passed the bar doesn't mean they know how to teach. So, somebody asked if I think Kim K passed the California bar. No, I think that she already said that she didn't. Um, yeah. All right, everybody. Thank you so much for joining me. If you have any questions, please feel free to reach out. Please schedule a session to meet, a strategy session. I'll put the link in the chat as well. Again, and somebody asked in tutoring who decides the topic. I mean, you can. I always like start by saying, do you have any questions you want to address? But it's usually that you show up at the session with the work that I've given you the prior week. So, all right, everybody, thank you. And Samuel, you can use the appointment, the link to try to make an appointment. I think I'm booked for tomorrow, though. All right, everybody, thank you so much. Excited to have you. I hope I see all of you in class or one-on-one and all of that. I hope everybody here passes in February. If you guys need anything, please feel free to reach out. Thanks, everybody. Have a good night. Bye-bye.